Hello, folks. For those of you that don't know me, I'm Colby Knaus, and I'm an attorney here at Chuck Franklin Law. Today we're going to talk a little bit about the crime of contracting without a license. We're going to talk about what it is, what the penalties for it can be, what one of the main exceptions to the general rule regarding contracting without a license is, as well as what to do if you are investigated for contracting without a license. The easiest way to describe what contracting without a license is to basically say that if you engage in any aspect of a contracting job, from advertising to bidding to actually doing the work, and it doesn't fall within one of the statutory exceptions to the general rule on contracting without a license, you could be convicted of contracting without a license. So contracting without a license is a Class 1 misdemeanor. To put that in perspective, it's on the same level as, say, a DUI. The only difference is, with a DUI, there are mandatory minimum sentencing rules. Those don't apply in contracting without a license. So if you were convicted of contracting without a license, you could get up to 6 months jail, up to a $2,500 fine, plus an 83% surcharge. Or you could receive nothing but a fine. In fact, the minimum sentence for contracting without a license is a $1,000 fine. So at a minimum, if you get convicted of that offense, you're going to pay $1,000 plus probably an 83% surcharge. So we talked a little bit about what contracting without a license is. You can commit contracting without a license simply by advertising for construction services. You can commit it by submitting a bid for construction services, and you can obviously commit it by performing construction services. The important thing to note is that contracting is considered very broadly in this context, and so if you engage in any aspect of contracting, you could be convicted of contracting without a license. Now, there are exceptions to the general rule that prohibits people from engaging in construction services without a contractor's license. Probably the most common rule is what's known as the handyman exception. And the handyman exception allows someone to advertise, bid, or perform jobs within certain limits, and that limit is $1,000. So basically, if you're going to do a job and it's under $1,000, you can do it without a license. But keep in mind that that $1,000 limit includes materials. So if you're going to say tile a bathroom and the materials are $750, you can really only charge another $250 before you hit that $1,000 limit. One thing that people have tried to do and mostly failed at is to break up a single job into 4 discrete parts, all slightly under $1,000. That isn't going to work. The ROC and the courts will look through that, so avoid that if you can. With regard to contracting without a license, if you find yourself being investigated for contracting without a license, it's important that you remain silent. Exercise that right. Good men have died for it. Too many times people destroy a defensible and a winnable case by essentially confessing, and they think they're doing themselves a favor, but they're not. So the only way you're going to know that you're being investigated for contracting without a license is an investigator from the Registrar of Contractors is going to call you. And when they do, the only thing that should come out of your mouth besides your name is, "I want an attorney," and I'm not answering any questions. If you do that, they can't use your silence against you later, and you are not assisting them in convicting you. Now, if you do all that, you still could be convicted potentially, and if you are convicted, you get into restitution. And restitution is typically the tail that wags the dog in these types of cases. If you commit any criminal offense in Arizona and you cause economic loss to the victim, then you are required to pay them restitution in the amount of that economic loss. Now, a lot of times, the victims in a contracting without a license case will be trying to recover an incredible amount of money, basically to redo the job in its entirety, and that is not compensable as restitution. The only thing they can get, and the way that restitution is measured in Arizona for these types of cases, is the contract price minus any value conferred. Now, you can fight a lot over what, if any, value is conferred in any given case, but know that it's limited and that they can't recover for fixing bad work or anything like that. Thank you.